Good afternoon, everyone. We're going to make a start. So welcome to this workshop on an evidence-based intermediary liability policy framework organised by the Centre for Internet Society India with the Centre for Internet Society Stanford and with a multi-stakeholder panel of experts. My name is Jeremy Malcolm and I work with the Electronic Frontier Foundation. EFF are honoured to be a partner in a new project to develop some principles on intermediary liability that several of our panellists are also part of, and we'll introduce that in due course. But there have been a range of recent projects to gather and present evidence to inform intermediary liability policy, and you'll be hearing about a number of those from this panel. So why is this an important area of internet policy? Because online intermediaries are an integral part of our online communications. Although the internet does technically support peer-to-peer communications which don't have intermediaries, in reality the value add that intermediaries provide makes them in practical terms indispensable. And this has made internet intermediaries among the biggest online businesses. Apart from the economic footprint of their own operations, intermediaries also have the potential to facilitate economic growth and innovation throughout the economy by organising and facilitating access to information, data and user-generated content. But the role that intermediaries play is also one that directly impacts on human rights, including both civil and political rights, such as the right to freedom of expression and freedom of association, and also economic, social and cultural rights, such as the right to education and the right to participate in the cultural life of the community. And that is the focus of this workshop, which looks at how different liability rules that apply to various categories of intermediaries in various jurisdictions have an impact on the human rights of users, both within and outside those jurisdictions. The aim of this workshop is to come to a more in-depth and rounded understanding of what are the different classes of intermediaries, how they differ functionally, and if their differing roles should have an impact on their responsibility with regards to protection of human rights. So we'll be hearing from a distinguished panel of experts from across all the stakeholder groups who will be presenting and discussing ongoing research on this topic, or just giving their perspectives. So in order in which they'll be presenting, we have Maarten Huseweg from the International Max Planck Research School for Competition and Innovation, Giancarlo Frozio, who's an Intermediary Liability Fellow at the Centre for Internet and Society at Stanford Law School, Nicolo Zingales, Assistant Professor of Law at Tilburg University, Gabrielle Guillemin from Article 19, Eleni Hickok from Centre for Internet Society Policy, Francisco Vera, Advocacy Director from Derechos Digitales, Titi Akinsanmi, who's Policy and Government Relations Manager at Google Sub-Saharan Africa. I'm not sure if Titi is here yet. And Malcolm Hutty from the European Internet Service Providers Association. So if you are attending this workshop, hopefully you've read the background paper. I'm sure everyone reads the background papers of the workshops that they attend, don't they? If not, you can download a copy of that from the website, and it's worth doing. There's also a list of questions there which have been set out as possible discussion starters. And I'm not going to read out those questions, but if you do have a chance to look back on the IGF website, you can read those for yourself there. We also have some people who may be contributing from the floor, including Henriette Esterhausen from the Association for Progressive Communication. So a packed lineup, and so I think without further ado, it just remains for me to pass on to Maarten. Thank you very much.
Is this on? Okay. Hello everybody, can you hear me properly? Hi. Thank you, Jeremy. I'd like to talk today a little bit about my research, but I'd like to present a little bit in the form of a story. Back in the 90s, many jurisdictions developed a certain mechanism which they consider that incorporates a certain balance between, on one hand, a return of investment of the right holders, and on the other hand, public interest for internet as a public space that is conducive to both competition and innovation. This compromise was included in a framework of the safe harbors, of different kinds for different services. I think there will be something said about this today. What I'm going to talk is something different. Is that today, 2 decades later, many states are trying to revisit the social contract. The claim is that a technology, in the meantime, changed the equilibrium. The hope is that if we empower the courts with the possibility to impose state-of-the-art measures on intermediaries, we will be all better off. So let's have a brief look at Europe. In Europe, the law-abiding intermediaries, internet service providers, which are covered, so even those who are covered by safe harbors, are nevertheless sued increasingly in private lawsuits by intellectual property rights owners who are asked to assist the right owners in enforcing their rights. The claim is not that they're liable. The claim is that they should help the right holders to improve their situation by employing certain measures. So the line of liability is not any more important. It's accountability without liability. This line is overstepped by an instrument of injunctions. So injunctions serve the aim of increasing exposure to accountability. Thus, even intermediaries who diligently deal with the content and who did nothing wrong can still be subject to forced cooperation to the benefit of right holders. Now, this can be both bad or good. So let's have a look at a story which I think illustrates nicely the problem. In 2010, German Federal Supreme Court was hearing a dispute about open Wi-Fi's. And the question was, should the private owners who open up their Wi-Fi's password protect their Wi-Fi's in order to help the right holders, or can they leave it open? Well, the court did a balancing exercise. The exercise the economists would probably see as an exercise of improving or increasing or decreasing social welfare. So it took their interests at stake and their respective costs. So look at the private users, and it's seen that it's negligible for the private users to actually password protect their Wi-Fi's, and that even for the security reasons it might be a good idea. On the other hand, for right holders, it thought there is a better chance that in the future they will enforce their rights, plus that some infringements won't happen because some of the people would just don't have any means how to protect themselves from being unveiled. Now, BGH, the German Federal Supreme Court, as a consequence, decided to password protect the Wi-Fi's and rendered a rule which basically said that in that particular case, the individual had to protect the Wi-Fi by passphrase with a certain technology. Well, the problem was that not even a few weeks after the ruling, public started asking, what is the scope of this decision? Does it also apply to commercial users like shopping malls, municipalities who wants to open a Wi-Fi to public, or cafes? Is there any time limitation for this rule? Can we revisit it in the future? Is there any hope for that? That all became open. And as a consequence of this, German landscape of Wi-Fi's started lagging behind the rest of the world. So even the Spiegel, the national magazine, weekly magazine, ran an article which basically said, was crying about this development, asking and reviewing certain sources, coming to the conclusion that there is a problem and the people see it as a problem. Now the question could be, of course, the court didn't necessarily mean it that broadly, and the question could be still raised whether in that particular case, whether the court really meant what it became in a society. But the problem is that innovation at least struggles to get through, because of course open Wi-Fi in the meantime became an important tool for competition, but also for different kind of innovation that the court didn't think of at that time. So did the court do something wrong? Well, an exercise of reallocating of existing resources really should have made everybody better off, but it didn't. And it didn't exactly for the reasons why inventing a car is more welfare maximizing than any sophisticated reallocation of horsepower. So the court, looking at a static picture of the Wi-Fi and the measures existing at a point, was really right that reallocating existing resources would actually be a good idea in a form of protecting the Wi-Fi. But a problem was that inventing any invention that is based on open Wi-Fi, and indeed it's crucially, will struggle with this. And this invention could increase the social welfare way more than any reallocation of resources by protecting the Wi-Fis. So, to wrap it up, the ambition that the courts will be able to set up most efficient balance for us by means of injunctions, which we'll try to seek, is very ambitious. It's very ambitious because the courts often do not have the information, and the society does not necessarily benefit from open-ended accountability of intermediaries, and the cost of uncertainty can be very high. Technology might temporarily change the equilibrium, that is right, but it's exactly the same technology that can restore it. Consider the filtering technology and filtering capacities, which, for instance, which of course increase the capacity of internet service providers to detect and enforce the rights, but at the same time, that same technology can also assist right holders before, for instance, they file notice. So this was something that is happening mostly in the European Union these days, with injunctions that can be issued also against those who do not infringe or are not even found secondary liable. But this is spreading further. It's spreading to other countries. Other countries are inspired. So as to European framework of accountability without liability, I think it needs a reform. And this is exactly what I work on. And if you're interested, you can look at www.accountablenotliable.org, and when the research is done, it will be all out there. Thank you.
Thank you very much, Martin. And Giancarlo is going to follow up.
Hello, everybody. My contribution will be more brief, and what I will try to do is to tell you something about an evidence-based approach to policy in the intermediary liability field that we've been carrying out at the Stanford Center for Internet Society. As you may have understood, as has been already hinted at, one of the key question of the intermediary liability conundrum is about consistency, is about the necessity of having clear definition, because the regimes differ too much throughout the world, and intermediaries cannot cope with these differences, and the side effect is that user rights have been hindered this way. What we have done at CIS in order to come up with an evidence-based approach to intermediary liability policy making is to create what we have called the World Intermediary Liability Map. We have mapped legislation, case law, and additional resources about intermediary liability throughout the world. So far, we have covered about 70 countries, and the goal is to have a country page for each jurisdiction in the world, so that those information may serve as a valuable basis for any type of policy making in the field. This is a step one of the project, and we want to proceed further, still looking closely at the necessity of having clear definitions in the field of intermediary liability. What we are trying to do right now is to come up with an enhanced website in which we will include this information we have collected so far, and we will try to aggregate those information in a better way. to come up with that better aggregation of information, we are trying to come up with a taxonomy of what intermediary liability is about. And so we are trying to define clearly who the intermediaries are, which are the subject matter relevant for intermediary liability, which are the legal instruments used to regulate intermediary liability that can span from legislative, administrative. We have seen an increase in administrative tools in order to tackle intermediary liability issues, self-regulation, and then the measures that have been applied in practice in order to deal with intermediary liability. Then a definitory work should go in the direction of understanding which type of liabilities are out there in the various jurisdictions. And so the scope of my brief talk here today is exactly to tell you what we have done, what we plan to do, and that the creation of this taxonomy could be done in a very collaborative way. So we are coming up now with this taxonomy in order to define clearly what the intermediary liability conundrum is about, and we'd like to open this process to collaborative participation. There are many stakeholders here at this table and in this room already working on similar projects, and so I think it is the moment to join forces and trying to come up with a common understanding of what intermediary liability is about in order to provide legislators and policymakers with those evidences in order to come up with meaningful norms and provision to regulate the matter. And this is all on my side.
Thank you very much, Giancarlo. So we're sort of going in order of stakeholder groups, as you may have noticed. So we're sort of starting with the academics, then we're moving into the civil society, and then we're moving into the private sector. So next on the list we have Niccolò Zingales, Assistant Professor of Law at Tilburg University.
Thank you. Hello, everyone. What I wanted to tell you today is basically some of the research that I've been doing, and also what are the next steps that I think are important in this space. I worked on a research on the notice and takedown procedure in particular. So looking at the systems that are in place in different countries to respond to requests of takedown and the extent to which the users were involved in this, in the basically adjudication that intermediaries sometimes are required to undertake when they are addressed with these requests. So the key issue is that we need more user involvement in this space. We did a review of several legislations. We have a paper with the Association for Progressive Communication that is posted online and is trying to identify some best practices from several intermediary liability regimes that could apply to the African context. And some of the recurrent issues that came up were the fact that essentially because of the way the notice and takedown regime was structured, the content was immediately taken down presumptively, and basically the user whose content had been taken down was only given at a subsequent stage the possibility to restore the content, put it back. This is problematic from two perspectives. One is that there is no due process, so no right to be heard, and this creates a sort of presumption of guilt. And then the second issue is that the freedom of expression can be hindered in this way. So essentially, it's against two principles that are well recognized by the human rights treaties. And the question is, how can we enhance the participation of the users in this space? So some of the regimes around the world provide for a notice and notice system, which allows the users to be informed and allows them to interact before the content is taken down. But improvement can be done also to regimes where this is not currently the case. So there are several ways to involve the users. One is in the notice and takedown procedure, a standardized form could be provided so that copyright owners or other right holders who are requesting the takedown need to address already the specific defenses which can be raised by the users. And so in this way, they will need to fill in blank spaces and say why these defenses will not apply. Another common safeguard that is used to protect against this issue is adopt a strict litigation sanction applied to any contents in which not only there is a misrepresentation, but there is the foreseeability that a defense could have been raised, that could have been valid. So in this way, inferring the knowledge that the content might have been legal and shifted the presumption in favor of the users. A third solution that has been suggested is the use of a reverse notice and takedown procedure, which functions in the following way. The user who would want to utilize a certain content that is protected by copyright and by technological protection system which impede the access to such content, can notify the users that he would like to make a public interest use of this work. And then, unless the copyright owner replies within 14 days explaining why this public interest use is not warranted, the users would be entitled to circumvent the technological protection system without being found guilty of violating the specific provision of the copyright law that condemns such circumvention. So this was a specific example about copyright, but there is the need for more involvement of the users also in other areas. And in general, the issue is multi-stakeholder cooperation in this space sufficient or adequate to enable the users to have a say, enter as part of the social contract, essentially. And on this, there are contrasting pieces of evidence. For example, a case in point is in the UK. There was an attempt to reach an agreement between the copyright holders and basically the content industry and ISPs regarding the cost for the filter that would be imposed then according to judicial procedure, but still you would need to decide how to split the costs. And this was supposed to be decided in a multi-stakeholder fashion, involving users as well. And because it was so difficult to reach an agreement that Ofcom in this case was supposed to broker, this eventually was circumvented by an agreement reached on a separate basis between ISPs and content industry, which essentially nullified the whole multi-stakeholder procedure that was tried to be followed. So in this case, multi-stakeholder cooperation didn't play a positive role. At least it wasn't able to deliver an effective agreement in a short time period. However, there are other areas where we are hopeful that multi-stakeholder cooperation will play a major role in the future, and this is what we want to do with the dynamic coalition on platform responsibility. Here I just want to put a plug to something that we will do tomorrow. This will be the first meeting. Essentially, with this dynamic coalition, we want to analyze terms of service and the extent to which companies, online platforms are using this term of service provisions that allow compliance with basic human rights, particularly due process, freedom of expression, and privacy. And in this regard, I just want to invite you to join. There is a workshop in the morning from 9 to 10:30 about platform responsibility, and then in the afternoon from 2:30 to 4, we'll have the first meeting of this dynamic coalition. And essentially, the objective is to have a multi-stakeholder dialogue involving platforms, but also government representatives, intergovernmental organizations, civil society, private sector, etc., to define what are the possible model contractual clauses that could be adopted in order to secure the best efforts in respecting human rights by these platforms. So maybe we can expand on how this can concretely be done on a later stage. For now, it's over for me.
Thank you very much for that. And moving on again, Gabrielle.
Thanks very much, Jeremy. First of all, I'd like to present my organization, Article 19, for those of you who may not be familiar with it. It's an international free speech organization based in London. What we do is develop develop standards and are involved in court cases. And we base our work on international standards on freedom of expression. What I'd like to talk to you about today is our work on internet intermediaries. You can find a copy of this work on our website. It's called Internet Intermediaries, Dilemma of Liability. I'd like to tell you about the thinking and how we went about this work. First of all, we looked at different types of intermediaries. And so we determined there were 4 categories that were important. First, there was internet service providers. But there we saw immediately that there was some confusion because sometimes the term ISP was used to describe a number of internet intermediaries. So we defined them as access providers, so the one who give you access to the internet. Then we looked at the category of hosts and determined that we would define them as those who control a website or a web page which allows third parties to upload or post material. Then we looked at the other internet intermediaries in the internet ecosystem, and we found social media platforms and search engines. And there we saw that they had different functions, but that sometimes, depending on the courts or on the liability regime, sometimes they were considered as hosts. So for example, a platform such as Facebook or Twitter would be qualified as a host. And search engines, similarly, depending on the qualification in various countries and jurisdictions, could also amount as a host, even though what they ostensibly do may not be necessarily just offering space for third parties to upload content. In looking at this taxonomy, we were also very conscious of the fact that when you think about Google, a lot of people think about Google as such, but they also provide different services, so different legal regimes may be applicable to Google as a company. Then we looked at the different types of intermediary liability, and basically we found 3 broad models. At one end of the spectrum, we had a strict liability model, which you can find in countries such as Thailand or China, where effectively internet intermediaries are required to monitor content because otherwise they face criminal penalties or the withdrawal of their business license. At the other end of the spectrum, we had a court-based model where, in order for content to be removed, one has to go to a court with a complaint, and which is essentially based on the Communications and Decency Act in the US. In fact, this model has been very much endorsed by the UN Special Rapporteurs on freedom of expression, so that was also of great interest to us. In between, we found the safe harbor model, which is essentially a conditional immunity system, whereby in order to get immunity, internet intermediaries need to fulfill certain conditions. Sometimes it's only for certain types of content. So for example, in the US, you'd be familiar with the Digital Copyright Millennium Act. And in other countries, well, in the EU, for instance, it's a very horizontal model. So internet intermediaries will be fixed with, we will benefit from immunity from liability so long as they don't have actual knowledge of illegality. The problems with this model, especially the EU directive, are very well known, and I think they've already been touched on. The problem is, first of all, it's not very clear what constitutes notice. So very often an internet intermediary will get a complaint, but it doesn't really explain what the problem is, if it's a defamation claim, why it's defamatory, if any defenses apply. So there are problems around that. And very often, there was also a complete lack of clarity around what actual knowledge meant, not just in terms of you know, just getting notice, but also the legal basis. For this reason, we kind of tried to think about the sort of approaches that could improve the notice and take down regime. And then we found that in some countries, such as Canada, they had a notice to notice system. And so I think on some level, Nicola has already told you about it. And the idea behind that was that instead of going straight to the internet, to the intermediary for the content to be removed just upon notice, effectively, the idea was to place the dispute back in the hands of, between the person complaining about the content and the person who'd written the content, rather than the intermediary. Because we thought, and this has been touched on already, that internet intermediaries were not best placed to make these sort of judgment calls. Very often they have to determine whether content is defamatory or is it a copyright infringement. We thought it was not appropriate for a private company to make these determinations, and this was very much in line with the international standards that we found on this issue. So just a couple of points, but you can read more details about the policy on our website. But a couple of aspects that we thought that such a notice regime should have. It's like a more detailed notice to begin with, so explaining what the complaint is, where is the offending material, and so on. We also thought that it would be useful to have perhaps a fee, so that in order to stem the number of claims that are made, because very often, as we've seen in the notice and takedown regime, it's very easy for people just to complain about something. The content gets removed because otherwise the intermediary might be fixed with liability. And so that gives rise to abuse. And especially under the EU system, there's very little safeguards against abuse. So our thinking was that with a small fee, it might help fund a system of looking at, and then also stem the abuse. We also looked at what might be desirable in relation to criminal content. The main point here for us was that, generally speaking, the most effective way of dealing with content which may involve criminality is to involve the authorities. Because ultimately, although it may be less infringing of free expression to have the content removed rather than a prosecution, at the end of the day, if the content does amount to criminal activity, the best is to complain to the police and let them investigate and see whether or not it is worth pursuing. So I'll stop here, and we'll very welcome any further thoughts from my fellow panelists and members of the floor on this issue.
We will indeed have some interventions from the floor a bit later. I'm interested to hear what our representative from Google has to say about some of the suggestions about notice and fees for takedowns and so on. Titi from Google is in the audience, and she's going to participate a bit later. But before we move on, we do have a couple more speakers to get to on the panel. Eleanor Hickok from the Centre for Internet Society India is going to be next.
Hello? Okay, much better. Hello, my name is Elenai, and I'm from the Center for Internet and Society, based in Bangalore, India. We are a policy research think tank. I'm going to talk both about our research on intermediary liability and research that we contributed to a report that is being issued by UNESCO. Tomorrow there will be a session on that report. It is titled Fostering Freedom Online, the Role of Internet Intermediaries. And it seeks to understand how intermediaries both foster and restrict freedom of expression online. And in that research, we studied 3 different types of intermediaries: social networks, search engines, and ISPs, across 10 different jurisdictions and 11 different companies within those jurisdictions. Now, a section of that report looks at intermediary liability, and so we studied the intermediary liability regimes across the 10 different jurisdictions, and we looked at a range of models and provisions, ranging from jurisdictions that did not have intermediary liability provisions in place, jurisdictions that were developing intermediary liability provisions, and jurisdictions that had developed intermediary liability provisions in place. We noticed that in jurisdictions that did not have liability regimes in place, it created both procedural and regulatory uncertainty, particularly for international companies operating or providing services within that jurisdiction. For jurisdictions that are developing or have recently developed intermediary liability provisions, it seems that there's a trend to cherry-pick best practices from developed frameworks, but at the same time adopt it to local context based on content that wants to be prohibited, and at the same time also include additional provisions. So we're seeing intermediary liability regimes plus with retention mandates, with disclosure to law enforcement requirements, with requirements for reporting cybersecurity threats that the intermediary might find. And within the jurisdictions that do have developed regimes, I think Gabrielle has talked a lot about the gaps that exist, but we also saw that there's a often broad content that is prohibited. And these are increasingly including terms such as cybersecurity or anti-terrorism, and we are finding they are not aligned with constitutional norms in a jurisdiction. We also saw models that placed the intermediary in the role of the judiciary, having to determine if content is legal or not legal, and sometimes also being placed in the role of the police, so proactively monitoring content online. Across jurisdictions, there was also a lack of due process and a lack of remedy. Now, the report is not just about intermediary liability. It looks broadly at content restriction online. And I think, along with all these other efforts, it's just a scratch at the surface of research that we need to be doing into understanding evidence that needs to go into these intermediary liability regimes, including, as Nicolo said, how these regimes are really impacting users and how they're changing their behaviors online because of the regimes. I think that's...
So when will the report be available, Elena?
Hopefully in the next month or two, it'll be finally published.
Very good. Thank you for that. And moving on to Francisco Vera, Advocacy Director from Derechos Digitales from Chile.
Oh, there. Well, good afternoon. I will speak about our intermediary liability regime enforced in Chile on copyright and how that has changed the panorama even globally with the TPP negotiations. As you all know, the US standard on copyright intermediary liability was set in 1998 with the DMCA, consisting of a notice and takedown regime, which was pretty much flexible. You just had to fill a sheet with your data and stating the content you want to be removed, like an affidavit saying that you are responsible for the content of that statement, and then the intermediary that received that notice should take down the content or otherwise be responsible of the of it. Of course, there's also another sub-procedure that in which the intermediary can forward the content or question the notice, but this is not the focus of what I will say. What I will say is from that rule or that act was started the ruling in the US around 1998. In 2004, Chile signed its FTA with the US and free trade agreement, in which Chile committed to have an intermediary liability regime on copyright. And the implementation of that obligation that was stated on our FTA started in 2007 until 2010, when our copyright law was passed finally, and it contains an interesting rule on intermediary liability, which is judicial only. What that means that if you want to take down content in Chile from an intermediary, you should formally go to court and ask for an injunction that the judge should analyze and provide, and then you should serve the ISP in order to get the content, in order to get the notice done, and then the intermediary can do whatever it wants to do. And also another mixed system in which you can you can notify the ISP, and the ISP can forward that notification to the allegedly infringer. What happened after? The USTR, the trade office of the US, was pretty much not comfortable with the Chilean implementation of our intermediary liability rule, and they started adding that issue in their 301 report, which is the report that the US has to determine which country is not fulfilling their standards for intellectual property protection. And also there was other consequence that was start drafting a new international agreement called TPP, the Trans-Pacific Partnership Agreement, in which they are now demanding to have this intermediary liability rule to be not judicial at all. And what the consequences are in here, and that's the important part, because the Chilean system has been reviewed in other workshops in previous IGFs, is that now what the US Trade Office wants is to get the DMCA exported to other 11 countries without any evidence. I mean, without any evidence supporting that that sort of rule is actually beneficial for the industry, but more importantly, for the public interest. The only statistic we have, or the studies, is that the number of notice and takedown requests in the US has been scaling almost exponentially. Now it's not that exponentially, but from 2012 to 2014, they augmented from 1,200,000 to 10 million, sort of, monthly. So what we have now is a really different scenario than the one that was envisioned in 2008, and sorry, in 1998. In 1998, there was no massive search engine with the capability of indexing almost every content on the web. There was not user media-generated platforms like YouTube or even other social networks that works with content provided by third parties. And now we have those. But also, we have some mechanisms which are actually bots or robots in the internet that are looking for this content and sending automatically these notices. So in 1998, there was this system when you did like this sort of swear statement saying that you had this content that belonged to you and you needed that content removed. And now in 2014, we have bots surrounding the net, finding content, matching content, and sending automatically these notices, which from Google transparency reports, we know that they receive around 10 million a month, but there are also many other different internet service providers or online service providers in the case of Google that keep receiving this content. So what happens now? There's no evidence of the success of the system for public interest. In fact, there's evidence on the other side saying that now setting up, for instance, any possible service in internet that works with third-party content will be submitted like the first day of their functioning to like now hundreds of thousands of notice and takedown requests done by automatic systems that actually are not considering not even the intellectual property problem. Now these are being used as an anti-competitive mechanism to discourage a new web page or services to enter competing or providing services in the internet. So there's this system that was born in 1998 that now has completely denaturalized, and it has turned into a mechanism to disallow competition, disallow new services in the internet, and most of all, that it's not serving anymore the public interest. I'm not saying that this is fault of Chile. I mean, we implemented the system in a manner which is consistent with human rights, especially in America. In our human rights system, we have a special prohibition of having censorship in the internet. And this system, in the manner in which it's applied with really informal notifications and takedowns, is not being consistent with that instrument. And there's a huge silence now from the Inter-American human rights system on this side. But just to know that when many people complain from this right to be forgotten ruling in Europe, which is like scaling thousands of requests, nowadays we have millions of requests taking down content from search engines, and many times those are not based, not even in copyright. So, and all of this, just to match with the title of this workshop, with no evidence at all that proves the importance or the service that this system is paying for the public interest, not for the economy, not for the competition. So it's pretty much odd that now what we have is like the TPP is a way for the US Trade Office to export their competitive disadvantage to have new internet companies to the rest of the countries that are negotiating the TPP. So there's no actual reason for some requests, but some specific interest from some industries that probably they are not even getting so much from the system, but a lot of comfortability of having these bots surrounding the net and keep taking down content. So just that out, I'm happy to keep that conversation going.
Thank you very much. And moving on to the private sector, we have Malcolm Hutty from the European Internet Service Providers Association.
Thank you. I'm also with Links, the London Internet Exchange, which is my day job, and I'm the chair of the Intermediary Liability Committee at EuroISPA. Both groups are essentially representative organisations for intermediaries. I'm speaking here in a private capacity. Liability. The first thing I want to address is something coming out of the discussion we've had so far, which is the so-called distinction between liability and forced cooperation. Now, I'm not a lawyer, but from a business perspective, this is getting awfully close to what my lawyer friends call a distinction without a difference. The idea of forced cooperation in practice means devolving to the court the power to make rules that the intermediaries must follow by means of an injunction, and then penalising them if they fail to do so. That penalty is essentially rather similar in business effect to actually imposing a direct liability, the main difference being that we are at least protected from the rather extravagant estimations by the audiovisual entertainment industry of the value of their product. So the idea of this, I'd like to come back to the principles. What is the idea behind this? It is an incentive mechanism. There is bad stuff on the internet, and the idea is that if you can place this incentive on the intermediaries, they should deal with it. They can make it their responsibility. Why? Well, there's an idea that we're very clever people, that we can produce grand tech solutions to society's problems. In particular, the expectation is that we will apply our usual approach in building solutions to provide services to people to produce capital intensive rather than labor intensive and therefore highly scalable systems. What this actually means is that what is expected, particularly from those that wish us to engage in preemptive regulation of unwanted or undesirable content, is that we should automate the problem. Now, an increasing part of our lives is conducted online. With the way that the growth of e-commerce and in particular the rise of social media platforms, this means an increasing part of our lives is conducted through intermediaries, which means that really quite a lot of what you do is exposed to what could be these automated systems if we are to be required to create them. Let's say, I'm going to set aside for the purposes of this discussion questions of technical reality, what's actually technically feasible and so forth. Firstly, because it's not that helpful, it doesn't add that much value to this discussion, and secondly, on the theory that what's not possible today might in principle be possible tomorrow, at least to a greater or lesser extent. But let's look at what the implication of more of our lives being conducted through intermediaries means in the context where you're asking intermediaries to deal with the bad things that happen. This change in this social change is essentially positive or negative according to your perspective. It's positive because it exposes vast areas of people's lives to regulatory enforcement, which enhances the power of the state to implement public policy in the public interest and to expect this to be executed. And it's negative for essentially exactly the same reason, depending on your perspective. Let me give you an example. I think many of the people in this room will be familiar with what's known as the Twitter joke trial. This was an occasion in the UK where there was a threat made against an airport, a threat of essentially to let off an explosive device. What happened was that a man, having gone to a small regional airport called Robin Hood Airport, came back from it and tweeted. I don't have it in front of me, I'm afraid, so I'm going to try to do it from memory. I think it went something like, Robin Hood Airport is closed, you've got 2 weeks to get your stuff together, I think it was an expletive, but your stuff together, or I'm going to blow this place sky high. This was followed by 3 exclamation marks. Now, he was prosecuted for making threats, he was convicted, and after several layers of appeal, the conviction was ultimately quashed. This case was significantly criticised on the basis that any reasonable person could have seen that this was a joke and shouldn't be taken seriously as a threat against someone. Okay, so far so good. To me, the significance of this is that in any offline context, this would never have got anywhere near a court, not because we would have judged that that was a reasonable thing to have said or you didn't mean it or you should be allowed to get away with such things. It would have been because nobody noticed. This is what I mean by the increasing impact of more of our stuff being conducted online and through intermediaries. If we were to start automating on a massive scale the enforcement of the things that you're not allowed to do, then even supposing that we're able to do it, those sorts of decisions will be conducted by machines, and things that simply would have been part of, would have just slipped below the radar, however much it might be wrong, will suddenly become part of an effective, in the sense of practiced regulatory regime. So this really means that whether you like the idea of asking intermediaries to build big systems to regulate unlawful conduct depends on really what your primary concerns are. If you're principally concerned about paedophiles coming over the internet to get your children, about copyright piracy, about extremism online, and about people spreading untrue rumours, then you probably will think this is a great idea. If, on the other hand, you are greatly afraid about the overwhelming power of the state and big corporations and feel that people are already far too exposed to power, you'll probably be terrified of it. Before you make up your minds on this, I'd like to give an industry perspective as to how we are likely to have to approach the problem. We have natural commercial imperatives. What will be the things that we will have to take into account as we build any systems, however much they are automated or however much they are procedural? Firstly, we'll look for them to be cost effective. We're businesses, and we have to run what's a practical economic proposition. They'll need to be efficient. Certainly, they'll need to be legal. More than that, in most cases, we'll look for them to be respectful of government interests, of the government demand that we engage in this kind of activity and that we restrain unwanted behaviour. There's a difference between different political cultures and legal cultures as to how far intermediaries will go at the moment beyond what is legally required of them to restrain their users' behaviour, to do more through terms and conditions because that is what is wanted at a policy level. In some countries, providers are willing to go quite a long way in that direction, in other countries much less so. What we are unlikely to prioritise is extensive fact-finding in individual cases. We are unlikely to prioritise detailed examinations of novel and complex areas of law. And we will find it difficult to apply strictly complex and qualitative and subjective judgments of how legal qualifications are intended to apply to protect the rights of individuals in particular cases. Let me give you an example of how this has worked out already in practice, and one example in the country I come from, the United Kingdom. A few years ago, the entertainment industry, basically Hollywood, brought a legal case against ISPs in the UK asking us to block access to, or asking the court to require us to block access to certain copyright infringing sites. I see representatives of a couple of companies in the room. The site in question had already been sued by Hollywood for copyright infringement. A finding had been made against them that they were a primary infringer of copyright, and the damages award against them sent that site into bankruptcy. So this site should have disappeared, but it rematerialized essentially on something that really they just effectively, and I have to be careful speaking in public, but frankly, individuals stole the code from the company so that they could resurrect it as a Phoenix company elsewhere. This is, in short, whatever you think about copyright regulation, the most grotesque example of scofflaw that you could imagine. And the court was highly unsympathetic to the site in question the second time around. So the providers had an order against them made, the Hollywood won, and the providers were ordered to block access to that site. And the court was very clear in what it said, that it is going to this measure because, and having seen, and it's already been tested, that this site is completely illegal, they've had every opportunity to defend themselves, a finding has been made against them, they've acted subsequently in complete disregard of the law. We would not be making such judgments if these things were not the case. Subsequently, Hollywood has come and asked for orders to block the Pirate Bay. And the reaction of the providers has been, understandably, we're not willing to engage in continued in extremely expensive litigation in defence of people that we've got no interest in really defending. So those the applications against the Pirate Bay were made and not defended by the ISPs. Now, there was no finding that the Pirate Bay is an infringing site in the UK, but the court said, well, there's nothing in the UK, but they found it had a finding against them in Sweden. That'll do, so we'll pass the order against them. And the next thing that happens is Hollywood comes back to court with another long list of further sites that are said to be copyright infringing, against which there's been no finding of primary infringement in any court or anywhere in the world. But again, for reasons of cost effectiveness and because it's really not our job to be defending other people's rights, there is silence from the ISP benches as to whether or not such an order should be made against them, and such orders are made. So we've moved from a position where the courts said it is essential that there needs to be primary findings in individual cases, to ones where courts are now routinely churning out long lists at the behest of plaintiffs, where there is essentially nobody on the other side, because of the imperatives, the natural commercial imperatives that I mentioned. Now, this, I should not say, is a criticism of my industry. If you don't like this, this is ensuring that this is regulated properly is a social function. It is not one that you can reasonably expect to be left to profit-making entities. The consequences, however, the economic consequences of this for our industry are significant. Certainly, it makes it harder to invest in new types of online services that are likely to be targeted for specific enforcement measures and that are likely to be subject to liability or to the so-called forced cooperation regime instead. And the other thing that is particularly expensive for us, though, is that when we are required to engage in some sort of solution, while the cost of that may be recovered at a given point, what we have found is that the real costs of that apply further down the line. We implement a solution, it has a certain cost, so be it. But when we then need to change our networks or systems, we can't just throw that away because it's a court-mandated or legally mandated solution. And therefore we have to design around the old system. And therefore the enforcement mechanisms gradually accrete mechanisms that we have to continue to apply with as we are trying to develop systems to develop, essentially extend broadband to the next billion and bring super fast broadband or whatever it may be. Essentially what this means is that the costs can be quite extensive but further down the line, and it retards our ability to bring new products to market. So those are the issues from a social perspective and the economic consequences for our own industry. Where are we? I would say at a crossroads. We have a choice in what approach we prefer best. We either rely more on a traditional, essentially court-based and offline mechanisms for regulating behaviour and regulating disputes. The downsides of this will be that it will be costly and costly to the public purse. It will tend to be slow, and in particular, we will lose a great deal of the opportunity to extend regulation much more deeply into people's lives so as to implement the public interest. Or we could rely on intermediaries to develop and automate systems to control our behaviour. This doesn't have those sorts of problems, but does have other problems, both in terms of hindering the development of the information society and potentially yielding up many of the things that we've traditionally expected as the protections of a free and liberal society. The choice is yours.
Well, what a great way to end our panel and to go to the audience. So what does the audience think of that rather stark proposition? Nick has his hand up. Would you like to... Oh, do we have a microphone that can go around the room? Jyoti, can you check? So we'll start with your comment, Nick, as soon as we get that microphone.
Malcolm,
You take the back, I'll take the front.
can we give briefly...
While we're waiting, you can respond, yes.
To Paul Fellinger from the Internet Jurisdiction Project, because his project is overlapping very much with this evidence-based approach as far as they are identifying trends in intermediary liability, case law and legislation. So maybe he would like to introduce that and the workshop they're going to have tomorrow.
Thank you very much. I'm Paul Fellinger. I'm the manager of the Internet and Jurisdiction Project, and well, that was a really great overview of the state of art of intermediary liability and the different projects that are going on worldwide. Let me stress one thing that you evoked but did not really mention. A lot of those requests that intermediaries, so platforms and technical operators receive today are increasingly transnational. So those are direct requests from courts and public authorities located in other countries that cannot be directly enforced on them. And at the same time, traditional modes of interstate legal cooperation are not adapted to the digital realities of the internet, where most online interactions simultaneously involve multiple jurisdictions. So this situation creates a lot of tensions, and you highlighted this in your different interventions, that there's a general lack of procedural standards for the submission of requests, for the handling of requests, the making of determinations, and then there's a lack of due process, transparency, and also appeal mechanisms in that regard. So we have a workshop tomorrow at 2:30 in room 2 that is called Will Cyberspace Fragment Along National Jurisdictions, where we will discuss the unintended consequences of the different national approaches that are currently adopted that do not take into account the transnational nature of the internet, and we will present the state of the global multi-stakeholder dialogue process that is the Internet and Jurisdiction Project, and present the transnational due process framework draft architecture that is an outcome of this process. Thank you very much.
Thank you, Paul. Nick?
Nick Suzor from Queensland University of Technology. Thank you. That was a really, really interesting panel. There's an essential tension here between efficiency on the one hand and due process user rights on the other. And I wonder if you could reflect, is this always a zero-sum game? Is there any way that we can have both efficiency and due process? Whenever we see examples like the judicial process in Chile or in New Zealand, the rights holders in particular in copyright have become relatively upset with how much that process becomes more expensive, more difficult to manage. Does it always have to be opposed in that way?
Who would like to take that?
Okay. On the international side, just one small note. I think when you have multinational problems are mostly, in my experience, due to copyright rather than other content, because other content sometimes are like defamatory or something, and more interest in more national interest than international interest. But in that case also, some platforms that you have are in the cloud, which means a data center in Arizona. So most of the cases you end up using US legislation and the DMCA in case of copyright. So even if small countries have a really good system on notice and takedown, it's not like as important today in the current setting of the internet. On the efficiency, we do have a position in here in Derechos Digitales, and we have, when we have doing advocacy on the TPP also. I mean, it's important to have an efficient judicial system and to safeguard the rights, but also we need to face the fact that there are other rights at stake in the world. I mean, there's also many other problems related with real estate, with child support, with cybercrime. So when you say we need a really efficient system for copyright to survive, I mean, first, that's not entirely true, because copyright has been really good to survive, or the content industry to survive with increasing amounts of content distribution, non-legal content distribution. And secondly, it's like we say we want to prioritize copyright every other human right or every other possible right. I mean, if you have a country where you can have a really good judicial system efficient for all of those cases, I would totally support an efficient copyright case, but keep stating and pushing copyright over every other right, especially through FTAs that have to be accomplished and enforced in many ways. I really don't see that that's consistent with public interest.
Just very briefly on Paul's point about the transnational aspect. As regards the content of the request, I think that's where international standards on human rights can be very useful, because in a way it's a way of harmonizing the various laws on content regulation. So that would help resolve some of the conflicts in a way of what is legal in one country and what is not in another, by looking at those standards instead. And similarly, those international standards help in defining the procedural safeguards that are necessary in order for these requests to be examined, like the right to notification and so on. The other aspect, I think, to this is that a lot of these requests are also likely to be dealt with under terms and conditions, which is an aspect we haven't really talked about, but that's something that we really need to have in mind, because a lot of those requests don't even go through that process. It's just they can be taken down under terms and conditions. Secondly, on efficiency and due process, I think it's a tough one, because to a certain extent, due process is like a thorn on your side. It's how you safeguard rights. But any procedure almost inevitably will make it lengthy, and it will be hard to be efficient just because you have that procedure, but it's also how you preserve rights. It's also one of the reasons why between like court orders, which is our preferred model, and notice and takedown, where there's so little, close to nothing, we thought that notice to notice was a good alternative to at least have some process, try and have some dispute resolution mechanism between the parties concerned, and then if that can't be resolved in that way, then take the matter to court.
Judy Akansami from the audience from Google. Does Google have a position on this? What's the preference between the notice and takedown regime, which is easily automated, and then the more human rights respecting regimes that are more in accord with perhaps your stated values? Do you have any remarks?
Okay, I'm not Titi. She's left already. Yeah.
Okay, maybe we'll come back to that. We also have a remote participant, but do we? Do we have a remote question? Yes. Okay, let's take that first, and then we'll go to the other people who had their hands up. Thanks.
We have a question from Reinhard Fuchs from European Law Students Association from Austria. His question is how the panelists see the first instance judgment of Delphi AS versus Estonia of the ACHR, and what they think will be the outcome of the Grand Chamber decision.
Maybe I can. So the opinion. So the question was, as far as I understand, what do we think?
I can repeat if you want.
No. Let me just say and tell me whether this is correct. So the question is, how do we see? What do we think of the first instance decision of the ACHR in Delphi versus Estonia, and what do we think will be the outcome?
Yes, outcome of the Grand Chamber decision.
Okay. So. As some of you may know, I personally am very critical of the first instance decision because I think it sets the wrong incentives for the intermediaries, and I think setting incentives is only an extended way how the state acts. So for the future, we should not have the state imposing strict liability on intermediaries in the cases where the third-party content is being concerned, and especially if it's a defamation case, where the bar should be actually even lower than in intellectual property cases. Now, my opinion of what the Grand Chamber will do, I can only say I'm hopeful that it will follow what amicus curiae, or intervention, which I authored on behalf of the European Information Society Institute, suggested to the court, and that is that a court will require as a human rights standard when it comes to freedom of expression that no general monitoring obligation is imposed on intermediaries, which means that it will outlaw any strict liability in defamation cases when it comes to third-party content, which means that the states will be pushed to any kind of negligence-based or any other standards. And second, that it endorses with its analysis that intermediaries should be safe in the process of determining whether to take down the content or not. It should be endorsed in giving the opportunity to the originator of the content to give an opportunity to defend his case, and only after that take an action. So that's what I hope what the ACHR will do. What it will do, I don't know.
Henriette. Sorry. Shall we add you to the list? Okay. The first hand that I saw was Andrew Bridges. Do you have the mic? Yes.
Thank you. I wanted to flag for attention and consideration long term two types of online intermediaries that I don't think I heard discussed here. And those are the two types of intermediaries that the Stop Online Piracy Act sought to regulate in a way that has taken effect, even though SOPA failed in Congress. Thanks to the White House Intellectual Property Enforcement Coordinator, payment processors will go to their customers and say, we don't want to process payments any longer for peer-to-peer software providers or VPN service providers or Usenet service providers, and so we are cutting you off. That's happening with no due process, you can argue with the bank, but there's no process for dealing with it. And they have never had a seat at the multi-stakeholder table to discuss these processes, like a six strikes type policy. The other is advertising networks, who, because they are dependent on certain very, very large advertisers, will cut off websites from syndication, saying, well, you have made some of our big customers unhappy, and we're cutting off advertising syndication to you until you make them happy. When you get them to tell us to add you back to the list, we'll add you back to the white list, and meanwhile you're on a black list. So these are two types of takedown that are occurring with none of even this informal process in place. And it's something I would love to see everybody studying these issues to wrap into their work.
Yes, thanks for that. And we've already heard about the platform responsibility workshop tomorrow, where that may arise as well. I am going to jump to Henriette because she was going to be a panelist anyway. So Henriette, if you'd like to make your point.
Thanks, Jeremy. It was sort of also more a process for going forward. But I think thanks very much to the panel. It's really, really interesting to listen to this. And I'm glad the Adelphi question came up, because I think it's an example of how even human rights experts in the judiciary don't understand this context. And so it's lack of procedural clarity, definitely, but it's also lack of really understanding the full range of implications. Also, I'm not sure if people saw on Twitter that apparently the IGF YouTube live stream is not available in Germany because of copyright bots blocking it. My suggestion was for the next IGF, would it be useful for us to facilitate a kind of net mondial type process where there's some scoping background information on intermediary liability and then some gathering of text, gathering of different positions, building towards the 2015 IGF in Brazil, coming up not necessarily with complete consensus between the different stakeholders about how to regulate these issues, but at least some common understanding of what the issues are that are at stake. Would that be a useful exercise? That's a question.
Thank you, Henriette, and maybe that provides a useful segue into something that I was going to mention, which is that EFF and the Centre for Internet and Society India are announcing today that there's a new project to develop a set of intermediary liability principles, which you can see up on the screen, a zero draft white paper, which is the very first public output for discussion. At the bottom of the first paragraph, you can see a tiny url.com URL where you can go. If you can't see it, then please come up later. We'll try and leave it up on the screen so that you can get it down. So this is not a, by any means, a fixed document. It's the very, very first iteration. That's why we're calling it a zero draft. But we want to get it out to the community to have your input into it. A number of our panelists are on a steering committee, as are some others who are in the audience or elsewhere at the IGF, who will be trying to get this into a first draft shape at a meeting in October, and then following that, once the first draft is ready, we'll be going out again into the broader community, getting as many people as possible to give their input towards a final set of intermediary liability principles that we'll be able to present and launch next year. So please do take the opportunity to take down that URL and have a look through the Zero Draft White Paper, bearing in mind that disclaimer that it's not representing anyone's fixed position at this point. We have 1, 2 at the back, and we have someone else with the microphone in the middle of the room, so please go ahead.
Great.
Go ahead. Excuse me. My name is Carmen Turk. I hope you can all hear me. I wanted to... You do hear me? Oh, that's good. I wanted to comment on this very, very good panel, which had a very, very wide variety of views. But I just wanted to comment that, you know, notice and takedown system has its very big downfalls. Notice and notice to notice system has its downfall because we have this anonymity problem. Let's say it like that. It's not really a problem, but some people might say that it is. So I don't think there can be one single solution that could be applied to all different kind of content. For example, hate speech needs one kind of approach. Then we have a defamation that needs totally different approach, and you can't really have a defamation content to be regarded without due process, even though it does take time and it's not efficient. However, it's not possible to change our community and say that, well, we want everybody to act nicely, and we want everybody to have only good things to be said to other people. So we can't shape internet because of that. However, to the commenter or the remote participant who asked about the Delphi, I want to, since this is very cute and nice case for me, I wanted to say that I totally agree with Martin, the moderator, who said that hopefully Grand Chamber will decide in favor of Delphi in this matter, because I think it could have a very huge implications for Europe, as many of the panelists are aware. But Irish Supreme Court has decided that they will not apply Delphi European Court of Human Rights decision from the last October 2013. So I think this is also a way to go if we do have some member states who have not been able to apply e-commerce directives, such as Poland, because they have a lot of cases where the strict liability is being applied to intermediaries, as well as my own country, Estonia, where the Delphi case arose from, where the strict liability has been seen as an answer for defamation.
We have 5 minutes left, so I'm going to ask the remaining 3 people to take only 1 minute. Yes, Eleanor in the front, you're one of the 3. The remaining 3 people to just spend 1 minute on their question so that we can go to the panel to round off. And so we're collecting the questions, then we're going to the panel. Thank you.
Great, thank you. My name is David Ferris from 21st Century Fox. So I represent somebody from the copyright industry. And I just would like to say we are gathering a lot of data about the different efforts to work with intermediaries to address online copyright infringement. And we'd be happy to share it with any of you as you develop your research. Just one piece of evidence that I would like to provide, it's actually data. You might recall that the European Commission had a notice and action consultation. And as part of that consultation, we did a review of the number of notices that we sent and the number of counter notices we received. So I'm just going to provide you one example due to time, but we sent almost 7.7 million notices to cyberlockers. We actually received 1 counter notice. So in percentage terms, that's 0.0000001%. So the data demonstrates that we take our responsibility as rights holders very seriously to do a robust review of the content that we ask to be taken down. And we also offer that counter notice procedure for the users. And again, 1 user actually used it out of 7.7 million notices sent to CyberLock.
Thank you. The panel is champing at the bit to respond, but let me go to the other question at the back, and then we've got one more question at the front. No, I think it was the gentleman at the back. Sorry, we're not going to be able to take all the questions. I apologize for that. So we have one here and then one at the front, and then back to the panel. Thank you.
Sorry. Yeah. My name is Prashant. I am from the Software Freedom Law Center in India. In India, we did a detailed study of the intermediary liability regime. We did a set of roundtable consultations across the country and also studied laws in various jurisdictions. We have come out with a report which is available on our website, www.sflc.in. So what we have done is we have arrived at a set of principles. Since you are also coming out with a new set of principles, I think it could be useful. And what we discussed mainly with respect to the regime in India was that there is no putback provision in India as of now. Apart from that, there are various ambiguous provisions which makes it very easy for anyone to get any content taken down. So, these are things that need to be discussed and what can be done. And we have now given it to parliamentarians so that they can come out with better laws. So, yeah. Thank you.
Thank you. Eleanor?
Hi, my name is Eleanor. I'm from Association for Civil Rights in Argentina. We have made some kind of research and also litigation because we have a lot of cases in Argentina regarding to intermediary liability that are about defamation and right to image and not copyright. So it's interesting because it's not only the copyright point of view about intermediary liability, which is also available at our website. And I want to point out that under the umbrella of the Inter-American human rights system, we have a new report that I think that Francisco has also mentioned on internet and freedom of expression under the standards of the Inter-American human rights system. And I think that the report is very useful to inform these kind of principles that and the process that you are announcing, and also for the work of other advocates in the world, which maybe they are not under the umbrella of the Inter-American human rights system, which is very generous in the protection of free speech. But I think that maybe we have to look more at, the dangerous side of this kind of discussion is that we are always looking at what is happening in Europe, which is a complete different system of human rights protection. Not completely different, but with more protection on privacy and other rights vis-a-vis freedom of expression. So we have to look more what is happening in other regions, like, for example, Latin America and the Americas. And I absolutely encourage everybody to look at this OAS report, which is, I think, very useful to protect the intermediate and to protect free speech in this area of
Thank you very much. I apologize that we're not going to be able to take any more questions from the floor. We have run out of time, but we are going to go back to the panel just for a final few words from each of our panelists. Let's just go from right to left, and it's the fairest way. Thanks.
I'd like to thank the floor for all your very interesting questions. Maybe I'll react briefly to the comment that was made by Carmen on Delphi and notice and notice. I certainly agree that uniform solutions, one size fits all, is unlikely to be the best approach. It may well be that we need to have a look at different types of content, but then we will run into the problem that something that are civil, that are criminals and civil and criminal, depends depending on the country. Sometimes something that's civil may be criminal in another country and vice versa. And on the Delphi case, just very briefly, it was a news site which brought into the equation a set of other problems to do with publishers' liability. But Article 19 was also involved in the case, and we are hopeful too. And I'll just close my comments here and pass on down the panel. Thank you.
Okay, only headlines. I totally acknowledge that private sector is not only like one position. I mean, we have ISPs, we have like intellectual property rights holders, so there's also some diversity within the constituencies. And also, of course, intellectual property industries are looking for their own profit, as any company should do. Having said that, the problem, and this is broader than intellectual property, when we have these notice and takedown systems, is that you create systemic incentives to take down content. Then having 10 million requests for taking down content in 1 month, denotes that there is a systemic incentive to keep taking down content. The fact of having only one counter notice, which is only the US system, that allows that mechanism, is also proof that there's not incentives to provide any counter notice. So if you tell me there's one counter notice, you are telling that there's only one case in which the takedown request was badly or poorly drafted. I don't think so. So what I am envisioning, and not envisioning, what I fear of, is to have a future in which bots will be controlling our speech in the internet by making takedown requests, by making preemptive filtering or collaboration with authorities. So that's what I don't want in the internet, and that's not compatible with any freedom of expression principle. So that's like the broader headline. Thank you.
Thank you. Firstly, Delphi in Estonia, Euroespro has also submitted an amicus brief on that, so I can only talk about that in the most general possible terms. And suffice to say that we believe that it's very important that hosting providers should be able to provide a platform for general public discourse. And if they are held responsible for everything foolish or unacceptable that somebody says, you are saying that such platforms cannot exist. That would be a social detriment that I believe ought to trump any individual's concern about a particular defamation. That's my view. With regard to some of the other points that were raised, firstly, the millions of takedown notices that were issued. Well, if you are under any doubt at the pressure that my industry is under from those that seek to regulate content, I believe that the intervention from the gentleman from Hollywood there will have set any such doubts aside for you. Clearly, there would be no counter notices in Europe, as Europe does not have a counter notice procedure, but we struggle with responding to the vast number of complaints that there are about people's actions and behaviours, and the approach that I've laid out for you is not one that we would enter into lightly or indeed particularly want to do. But how else do you expect us to cope with that sort of volume of requests? I would also, at this point, I think it's appropriate to draw in the comment from the front here about this isn't just copyright. Absolutely, it's not just copyright. There are a whole host of stakeholder groups that have problems with the ways that people behave online, and that also generate complaints to intermediaries asking for us to restrain that behaviour. So those millions from Hollywood are just a part of what we have to deal with. Thank you.
Just wanted to connect a few of the points that were made. So here we are very often talking about balancing of conflicting rights. So the freedom of expression of one, conflicts with the right to privacy of another, the right to be forgotten of one, conflicts with the right to know of another. So the problem is, how do you ensure that intermediaries take into account the different situations in which these rights are invoked, because these rights have a different weight depending on the situation. So I agree in that regard that copyright might be not the same situation as in the case of offensive speech. So one of the key issues is anonymity, the disclosure of the identity of the users. In the Delphi case, this was a very controversial part of the judgment. And this should also be balanced by the intermediary depending on what is at stake. So if anonymity was used to protect the right to life, to protect from a threat to your personal life, then it's clearly more important than if it's just for exchanging copyrighted files. And the same kind of balancing is to be done in other situations. So what we can do is formulate some presumptions which are in accordance with the case law, and that intermediaries can use to be guided in this balancing act. So I think that in this regard, the work that we want to do with the Dynamic Coalition is precisely to take a stock of the existing case law and suggest contractual clauses in the terms of service that are as close as possible to that, and possibly taking into account not only different situations like offending speech and copyright, but also the reality of different regions of the world where the case law is different. So I invite you again tomorrow to come to start this discussion, which I think it would be very important in the future to be sure that the automated enforcement towards which we are inevitably going to end up with the Internet of Things coming respects our fundamental rights.
I would like to thank the audience for their questions and comments, as well as pointing to research that they are undertaking or have undertaken. I would encourage you to come to the UNESCO session on Friday and comment on our draft report, as well as comment on this zero draft principles paper that CIS and EFF has drafted. And just quickly closing, I would like to reiterate what Henriette was saying about the need for capacity, and that when we look at intermediary liability and gaps within intermediary liability, it's not just about the regime, but also about those who are enforcing and implementing the regime, and that they have technical capacity and understanding as well.
And I'd like to conclude with saying, I first want to react to a gentleman who unfortunately already left, but if it's somebody who knows him. First, I'm interested in those resources. Second, I think it's tricky to use the data about notices in a way that is often presented from both sides, actually. First, because the number of notices never tells from how big is the pie, so we don't know from the what percentage. Second, the number of the counter notices filed also doesn't confirm that all the counter notices, all the other notices that have been successful are okay. The reason for that being is not only that ISPs do not have incentive, but also because many ISPs today try to operate under a US framework, which actually gives disincentives to encourage users to file a counter notice. So I would definitely be for restructuring existing counter notice system as well as notice system, because it both doesn't, but especially the counter notice system today does not properly enable the ISPs to encourage the users to first to actually induce them to file counter notice in case they feel that it's incorrect. But second, also the users today are given very strong, in a very bad situation where they file counter notice. They have to unveil their identity all the time, and there's many repercussions. And there are many middle ground solutions that could be done in and which would increase that number for sure, I believe. As a more general note, last thing I want to say is that I think when we draft all sorts of different solutions on intermediate liability, whether it's accountability, liability, whatever, we should keep in mind that the actors in a game will always respond mostly rationally. And of course, I understand that if the system does not protect the interest of the user in a particular way, and it's effective, it's cheaper for the either right holder or the ISP to react in a certain way, they will do it. It's actually our job to make sure that a framework will prevent that. And of course they will try to save on costs and find the best solution. PR is just one of the pressures. So I think this is what we should keep in mind when we draft those laws.
So let me remind that the comment of the representative of the right holders has brought back us to the key question that we're discussing here: how important is a well-done evidence-based approach to intermediary liability policy and regulation? Because I mean that's exactly an example in which data can be, if the process which they are collected and are used is not carefully reviewed, can be used in a deceiving way. Then those data are data, they're natural in itself, but I mean, on the other side, you may look at the work of Daniel Sang, PhD at Stanford, together with the work of the Berkeley and other institution takedown project, which is telling you that more than 20% of notices are bogus. And again, I mean, those data may be read in a totally different way. The very, very limited number of counter notices can just tell you that the counter notice system is completely inefficient, and that particularly because that counter notice system, as Marty just mentioned, is strongly influenced by the DMCA approach, is going to put liability on the users, so that the users are never going to use that, go through the counter notice route, because then a fair use decision they have to face on the use of the material is going to be an insurmountable burden to them. So that comment is a good example for us to say that it is definitely necessary to base any policy and to move forward in trying to fix the intermediary liability conundrum on very solid, evidence-based notions.
Well, that's a good note on which to close. I would like to thank all our panelists. I would like to thank the audience for your inputs, and also for staying almost 15 minutes later than our scheduled time, but that's the advantage of being the last workshop. We don't have to compete with anyone else. So hope to see many of you this evening if you're going to the Google event, which is coming up next. Otherwise, we'll see you tomorrow. Let's give a round of applause to our panelists.
What we need is for the notice to include a consent to the jurisdiction of the court where the user is located.
Oh, yes. Okay.
Right? Because the counter notice has to consent to the jurisdiction, usually where the ISP is, where the recipient is. But you could yeah, sure. Can I get a card? I've given out all my cards. I'm doing a lot of work on intermediary liability. I'd like to get back in touch. Great.
I actually didn't think of jurisdiction. I think a couple of other things.
Okay. Right now, there's a distance
Okay, that's fine. We would really love to add an Ecuadorian page to our map. I don't know if you happen to have seen it. Yes. Yeah. Okay. That's great. Yeah. And you saw that we have already several.
I teach that at the university, and I focus on my legal practice.
Yeah. That's great. So let's get in touch as soon as I'm back, and then we can work together.